This is Alison Forrest, July 7th, 2004, interviewing Brendan O'Brien in his home for the Law Society Treasurers Project. Now, Mr. O'Brien, we were just talking about the theme for today, which is legal education.
Yes.
And you made the point that it depended what you said legal education was.
Well, I can perhaps start by telling you my own legal education, because I was raw out of college. I knew nothing about the law really to speak of. So when I registered at Osgood Hall Law School, I took 2 hours every morning at the law school in lectures, and then the rest of the day I was articled to a law firm.
Right.
This went on for 3 years.
Right.
At the end of the 3 years, I was called to the bar. If I didn't have a university degree, it would have taken me 5 years. I would have had to go 5 years articling instead of 3.
Right.
And oddly enough, some of the leaders of the bar of my period all went the 5-year, but they didn't go to the university. They were the leaders.
Right.
Mr. Tilley, for example, is one who was leader in Canada, was a 5-year student.
Right.
Edson Haynes, and lots of others. But then I had to look back at the end of the 3-year period, and I reached the conclusion that about 9/10 of what I had learned was at the office, not at the law school.
Right.
In other words, the law school was valuable in a certain way, but it was in no practical sense. They couldn't tell what problems you were reaching there.
Yes.
The law office experience taught you how to be a lawyer. In other words, the law school didn't teach you how to be a lawyer. They just taught you snippets of law.
Right.
And those snippets of law might be useful or might not.
Right.
And, for example, if you take the common concept that you can't be held liable to answer for the debt of another person unless it's in writing. This is an elementary legal principle.
Yes.
You learn that at law school. But in your practice, we never had such a case.
Right.
Useless. So that you go through that period, and I still think, both in subsequent experience and in what I saw in my own experience, that the apprenticeship was by far the most important part of legal education.
Yes.
And the luck of the draw was that you got a good firm to be articled to, which I was most fortunate in having top lawyers who would take me with them on trials and appeals, so that I got the very best of experience. If I didn't have that, I know a lot of my classmates didn't. They learned very little. Articling periods, so that's the way it went.
At present, as you know, it's just the university stream, so it's the 3 years of
well, I think that
coursework.
I can tell you the fallacy of that by saying that when I went through, you could go either way. It's 5 years one way, 3 the other.
Yes.
But that the leaders of the bar of my period had all gone through the 5-year method. They didn't go to college.
Yes.
So that we who did go to college were at a disadvantage in the sense of practicing law. But we may have been, I think you could perhaps learn to express yourself a bit better by going to university. And you could put together a written argument better, but as far as the practical use of it, didn't work out that way.
Yes. You suggested in the same earlier interviews when you were talking about your legal education that the casebook method which was used was not a useful way of learning as well.
That's another separate problem.
Right.
The casebook method was used in the when I went 2 hours every morning to use the casebook method. And the casebook method meant that the lecturer had to, if he was teaching contracts, he had to find cases illustrating the concept of a contract that he wanted to impart to you. And he would find one case that maybe hit it on the head, one that didn't.
Right.
And but you might never have a case like that in your whole experience.
Yes.
So that it would be far more useful if you're in the law office and you took a contract case under your senior partner and learn how they handle it, than to take a case of somebody else's.
Yes.
The casebook method I thought was a failure.
Right.
At least I didn't learn much more.
Right. Right. So really, I guess it's like an apprenticeship system that you had versus now the higher education model.
Yeah.
That's the difference. Yeah. Okay, I'd like to ask you now about your experience lecturing at Osgood Hall.
Yes.
So, how did you come to teach at Osgood in the first place?
Well, after World War II, there was a great influx of new students and a great shortage of teachers, and somebody invited me to take on what was called first-year practice, which is not the theory of law, but how to conduct a case.
Right.
And I was capable in that field, so they employed me. And then when the bar admission course came along later, I switched from one to the other. It wasn't a very big jump, but it was a slight change.
Right.
And then that was the end of my continuing legal education. I did very little of that. I would mainly appear on a panel with others to discuss certain problems at a continuing legal education session. But throughout the whole of my experience, both as a student and as a lecturer, I found that the practical training was more useful than the theoretical.
Yes, and so that's what you were teaching then.
Yeah.
So what did you teach? So you said practical.
Practice.
So could you give me an example of the types of things that you did in the classroom?
The rules of practice are set forth in writing.
Yes.
And the practice course is largely familiarizing the students with those rules and make them capable to write an examination based upon what you've told them about the rules.
Right.
But it didn't have much practical experience in how you'd run a law office.
Okay.
Your law office might never have an occasion to use those rules.
Yes.
But that's the way it went.
And was this a mandatory course for all students going through? Yes, for both
they had the first year practice, and then the second year practice, and then the third year, there were 3 years in all. And I did the first year in the law school, and then later on the bar admission course, which is largely the same subject, except that in the bar admission course, it was more of a how-to rather than what the theories are. How to do it.
So it was more practical. Yes. Okay.
How to do it.
So with at Osgood Hall then, when would you have started that? You said after the Second World War. So
yes, it would be about 1946.
And for how many years would you have done that?
I did it for about a little over 10 years.
Oh,
until I became a bencher.
Yes.
Which was about 1960 or 61. Then I stopped teaching.
Right. And it was lecturing style courses for Osgood Hall. And how many students would there have been in the class?
Well, it started out after the war. There were very large classes, and maybe 150. But as time went on, it became smaller. I think we got down to about 75 to 100 in the class.
Right, still big classes though.
Big classes,
Yes. And did you have assistance with marking or teaching?
I can remember the board above. I don't remember exactly how. I may have given it out to others to do it. I don't know.
Right. Later on, I guess the most valuable aspect of my teaching experience was that I got a lot of votes from my students.
That's
Yes.
when I ran
Yes.
for convention, I was elected. But,
Did you keep up with a number of your students then, subsequent to
not
teaching
very
them?
much. No.
Not really?
No.
But they knew who you were through having been your student?
They would just remember you.
Yes.
Yeah.
Yes. So just a certain public profile, I guess.
Mm-hmm.
Yes. And did you enjoy teaching?
Yes. It had its boring aspects as well as its entertaining. One of some odd practical jokes. We had a professor lecturing at the same time that I was in, Desmond Horton. And he started his lecture this day, and a student got and said, "Could I make an announcement to the class before you start your lecture?" So he stood aside from the podium, and the student made the announcement to the face spurious, and he took the professor's notes, but when he went back to it, he had no notes.
Nothing left.
But, I didn't have any experiences like that. But, one of the other ones was Walter Willison was a lecturer, and at this time we were using Convocation Hall in Osgood Hall for the lectures because it was such a big class. And the night previously would have been a dance in Convocation Hall for which they had required a piano. And the piano was not far from where the podium was. And in the middle of Walter Willison's lecture, two men came in with a dolly on wheels to take the piano out. And of course, this distracted all the class from his lecture. And he suddenly wheeled on the two men. He said, "Get the hell out of here." He dropped the piano and ran. But the lectures were, for the most part, not very exciting.
Right. Did you, were you able to direct what you taught, or were you told by a committee, for example, what you should be teaching, the content of the courses?
Well, I set my own content.
You set your own content?
Nobody else.
Right. And do you have a sense how that was similar or different from other people teaching at the same time? I
think I pretty well followed the pattern of what predecessors had taught. I don't remember that much different.
Right.
But,
did you belong to an organization that included other teachers teaching the same thing in other provinces?
No.
And I wanted to ask, how many hours in a week would this have involved?
Would I have taught?
Yes, and marking and...
Well, I would say that my lecturing would, each time I lectured, be 1 hour.
Right.
And it would be either at 9 o'clock or 10 o'clock. And it would be maybe 3 days a week, so that would be 3 hours a week.
Yes. As well as all the administrative work that went with it.
Pardon?
As well as all the administrative work that went with
well,
teaching.
I didn't do any administrative work.
Right, so that
Except
was...
marking papers.
Right, right.
That sort of thing.
Right. So it's still a considerable amount of time away from your own practice.
Yes.
So, yes. How did it affect your practice in
Well,
your way?
only in a minor way, because my practice was not geared to any time pattern. In other words, I could do a thing today or tomorrow, depending on how time was available, and I had no real problem that way.
Right. And your firm was supportive?
Pardon?
Your firm was supportive of you doing this?
Oh, yes.
I was wondering also if at that time there was any payment for the lecturing, or if it was pro bono work?
I got paid some modest amount, wasn't very much.
Token.
I think it was $20 or $30 a lecture, something like that.
Right. So this is more in the nature of a service to the legal community?
Mostly, yes.
Yes. And do you think there is a value in having practitioners teaching students versus full-time professors?
Well, there was some. I think I got more out of it than they did.
Right.
Because in order to prepare for a lecture, I had to do a certain amount of research.
Yes.
And this was work that I wouldn't have done otherwise. And having done the research, then I was better qualified in the subject than I was. And that was the main value to me was what I learned in preparing for my lectures.
Yes, that's great. Now, I asked you earlier if you had kept in touch with former students. What about former colleagues who were also teaching? Did you meet a number of lawyers you wouldn't have met otherwise, for example, through teaching?
Well, in a general way, yes, but not in any significant way.
Right.
There's a lot of people I got to know in a sort of a functionary way, but not in any depth.
Right, right. Okay, we could just perhaps move on to looking at your bar admissions course experience as well. So you said earlier that basically when you finished with Osgoode Hall, you started with the bar admissions course.
Right.
And they were more or less the same type of course?
Same, only more on the how to do basis than on the theoretical.
So was it still lecturing, or was it a different type of teaching?
Lecturing, except that occasionally I would invite an outsider to come in.
Right.
For example, there was an English professor, and later on he became a Jesuit, McGarry, and he was in Toronto, and I got him to come to lecture to the students, and then I got him to illustrate how to cross-examine somebody. And I remember we had a fight as to who would be the witness and who would be the cross-examiner, because I finally got them. I was the witness, so I made all the mistakes.
Right.
It was quite interesting for the students. But occasionally we had episodes like that, but not very often.
Right.
Mainly it was just lectures.
All right. That's a difference now from the way it's taught. And what would the class sizes have been for those classes?
I would think the classes range from 75 to 100 somewhere.
Oh, so still large and still mandatory for the...
Yes.
Yeah. And...
well, now, wait a minute now.
Right.
I don't know that attendance was mandatory.
Mm-hmm.
In the sense that I never kept attendance.
Right.
So that...
It's mandatory to be registered in order to be called?
You were not to, yes, you had to sign up for the course.
Right.
But I don't think anybody checked you whether you attended or not.
Right. Right. And was this the same time commitment that you would have had, about 3 different sessions over the week, about an hour each?
Mm-hmm, that's right.
So it really is very
About
similar.
the same thing, yes.
And where were those classes held? Were they also
Well,
convocation?
they were, I think, practically all my lecturing was in Convocation Hall at Osgoode Hall.
Right.
And it was a large group in there.
Yes. And when you were walking backwards and forwards to your office, how long would that have taken? How far was your office?
Oh, the office was 5 minutes away.
Oh, so it was an easy...
No problem. In fact, out of my office window I could see the front door of Osgoode Hall.
All right. So close. And do you remember having any assistance with those courses, with marking or administrative matters?
I'm sure I did. Like, for example, having stuff printed and that sort of thing.
Yes.
Having marking and that sort of thing. That's what assistance.
And were the courses created by the Law Society, or did you create them yourself?
I created them.
And you were the only person teaching that course for bar admission. How many years did you teach that?
Well, I think the law school teaching occupied 8 or 9 years, and the bar admission course 3 or 4 years.
Right, and they were back to back.
Back to back.
So before you became a bencher.
No lapse time in between the two.
Right. And you talked earlier about the teaching, both bar admissions course and Osgoode Hall, assisting you in gaining a higher profile so that more people knew you. And you also said that it assisted your own practice in that you looked at material you might not otherwise have looked at. Is there any other way that it assisted you in your career?
I don't hear what you're saying.
You made 2 points earlier. I'm wondering how your lecturing assisted your career. Earlier you said you saw material that you wouldn't have looked at perhaps because you had to teach it.
Yes, I learned.
Yes, and you also said that more people knew you because you had been a teacher.
Right. That's right.
Was there anything else in any other way that assisted you in your legal career?
I don't think so. Those are the only two.
Now, while you were a bencher, you were on at least one committee to do with legal education.
Yeah.
Could you tell me something about that?
I don't remember any committee work that I did for the Law Society of any significance except discipline,
Right.
which had nothing to do with legal education.
No. Okay, so it wasn't something that you were involved in. What about the CBA? You weren't involved in any committee work that had to do with legal education there?
No.
Okay.
Not at all.
Was that through choice or just simply it never came up
Well,
at a time?
I used to go to the annual meeting of the Canadian Bar Association,
Right.
which is sort of a convention.
Yes.
Otherwise, I didn't have much to do with it.
Right.
And if you weren't on a regular committee of the Canadian Bar Association, you would become too connected with it.
Yes. Now, since you're a student in the late 20s and early 30s, legal education has changed a great deal and continues to do so.
Yes.
Do you remember any discussions while you were a bencher about education? And
Mainly discussion as to the value of articling and as to how they could get more articling positions available.
yes.
In other words, the students rightly complained that if they were going to be required to take articling, they must have the positions available to them.
Right.
And it was turning out that they wouldn't have them available to them. And the Law Society had to, I think, limit the amount of articling that you would take in order to
Right.
fill that out. Other than that, I don't remember any other discussion.
Now, continuing legal education is an important part of being a lawyer as well.
I didn't do very much of that.
Right.
I think I told you I did sat on panels and
Yes.
did discussions. And, these are irregular events and would last maybe an hour or two. That's about
Right.
it.
Right. So you'd be requested to come in and attend with other
That's right.
people. Right.
Well, you'd be asked to chair a panel or to sit as a
Yes.
member of a panel.
Yes.
If you were chairing the panel, you'd have to meet in advance or decide
Right.
what we were going to
Sure.
discuss. That sort of thing.
Right. When you started practicing as a lawyer, was it a mandatory part of being a lawyer to attend continuing education?
I don't think it was. I don't remember now, but I usually went to the lectures in the morning, but I don't require any attendance being taken.
Right. But for
I
yourself.
remember one occasion, the dean of the law school at this time was Dean Falconbridge, who was in his 90s, and he was much respected. And one morning, he had the 10 o'clock lecture, not the 9 o'clock lecture. And he'd no sooner get started on his lecture than the door behind him would burst open and a late student would arrive. So finally, he said, "I'm going to wait for one more student, and then I'm going to lock the door." So there was a long silence. The door burst open, the student came in, and went up to the back row, halfway in, got his galoshes and went out again. About 10 hours.
Okay, so what I wanted to ask you as well was if you did any continuing legal education for yourself, for your own learning?
Did I what?
Did you take any courses or participate in seminars?
No.
In order to assist your own learning?
No.
Okay. Because that's now a requirement, an ongoing requirement is continuous education.
Yes.
I wanted to ask you what you think about that. About the requirement for continuing education for lawyers, if you think that that's a good idea.
I'm not sure that I noticed what you mean.
Well, for example, every year, every lawyer in Ontario fills out a form, and part of the information they have to give is how many hours in the year that they have used to attend conferences or take lectures or whatever in order to assist their ongoing education. And I think there's a requirement of, say, 50 hours in a year.
I see.
And I was wondering if you had done that.
No, I've never, nothing like that.
And if you thought it was a good idea for lawyers to do that.
I doubt it. I doubt its usefulness. I think that this sort of enforced continuing education is of limited value as my own problem.
Mm-hmm. While you've been a lawyer, law has undergone tremendous change. So there's been further specialization with new technology.
That's
there's
right.
More information. All of
Well,
those.
the only continuing legal education that I think was justified and useful was where something new would be introduced.
Right.
A new method of searching titles, for example.
Right.
And then nobody would know how to do it unless they had
Right.
a continuing legal education course of a couple, 2 or 3 lectures that would acquaint them with this new system.
Right.
But aside from things like that, I don't remember very much of a useful nature.
Do you remember the issue of continuing legal education being discussed at all in convocation?
Not very much.
No.
Not very much. The main things I do remember were articling problems and continuing legal education as to subjects that had come up and
Right.
required elucidation, so that they would set up a system to teach them.
So what would be an example? A new subject area?
Well, I'm trying to think of one, but certainly a new registry office system
Right.
would require
Yes.
or maybe a new income tax system, something like that.
Right. Right.
Things like that required a lot of lawyers' practical side was sort of indirectly related to his practice, but he would perhaps profit by having lectures on it as well.
Yes. Now I wanted to ask you about the Law Society and legal education. So obviously they're very involved in students' education. I want to ask you what you thought the role
Well, don't
of it.
forget this.
Yes.
The law school, Oscar Hall Law School, at the present time has nothing to do with the Law Society,
Yes.
nor do any of the other law schools, Queens or
Yes.
Western, and
Yes.
the law faculty and the dean.
Mhm.
And they meet and they discuss things with the Law Society, but they're not in any way connected.
No.
It's
So what?
changed totally.
How would you describe that relationship then?
Well, they might discuss what the Law Society would require for a call to the bar.
Right.
How many years and what subjects.
Right.
Because I know there's been a lot of concern in the Law Society over the lack of teaching of basic subjects like evidence.
Mm-hmm.
Some law schools have dropped it,
Yes.
which has been deplored as a loss to the profession and to the public.
Yes.
That sort of thing.
So do you remember when that change occurred?
Well, vaguely, yes. It happened back at the time when Osgoode Hall Law School ceased to be an adjunct of the Law Society itself. It was originally run by the Law Society,
yes.
Osgoode Hall Law School. And when they dropped it, after a good deal of acrimony, there had to be a sort of a new bar admission course scheme set up, and then they had to meet and come together again as sort of outsiders.
Mm-hmm.
And this was in the 50s, I would think.
Right.
Early 50s.
Yes.
Went on into the 60s, maybe. John Arnott, for one, took a very active part in that.
Mm-hmm.
And Professor he worked with John on that. But the other law schools were set up. I think the Osgoode Hall, of course, was the first one, and then Western Queens, and so on.
Right, right. But you don't remember anything in particular, any discussions other than that it was somewhat acrimonious in nature?
Well, originally, when I was not, at the time when this acrimony was at its peak,
mm-hmm.
I was not a bencher.
Right.
So I only heard that as an outsider.
But you were a lecturer at that point.
That's right. But I used to, I remember a midwinter meeting of the Canadian Bar Association at Niagara Falls, and something was very hot at this time, and the complaints were being made about students, articling students being sent to do messages for their boss, like get the wife's hat fixed. Right. A lot of discussion of that sort, and very entertaining. That led to the change in legal education that followed, and the development of the present system.
Right. The final area that I'd like to ask you about is more general in nature, just asking you to reflect on what you think legal education is all about. And I wanted to ask you to start with, what do you think a law student needs to learn?
I think that from the beginning I entertained the view that apprenticeship was about 3/4 of legal education, and
mm-hmm.
academic training was about 1/4.
Right.
Not of any practical use.
Right. And what about the knowledge that they need to get before they start to practice? What types of information or courses or things do they need to know?
Well, it would, of course, depend on the type of practice. Most lawyers joined a larger firm, and they would therefore just blend in, as it were.
Right.
But if you're starting your own practice, you'd find it difficult to sort of chart a course of your own and to get the right blend of talent to set up.
Yes.
And the way it is even today, that the large law firms, of course, take most of the students, but I've found, only this is all hearsay as far as I'm concerned, but that most students today find the docketing of time extremely boring, and a lot of them dropped out of law for that reason.
Right.
You can't put up with the
right.
annoyance of it. I must say that in my day, I never docketed an hour of my time ever.
Right.
Nor did any of my compatriots. In my firm, we never docketed. We simply billed on a lump sum basis what we thought the services were worth, and that was it.
Right.
And it worked well. But the docketing came into being largely because the taxing officers who had the tax lawyers' bills had no practical experience. And when they had to tax the value of the lawyer's work, they didn't know how much time he spent on it. They couldn't say whether it was well done or not. But I think the docketing system resulted in largely what we call the spinning of wheels.
Yes.
They're docketing the time, but they're not doing it.
Yes.
So that I think the practice of law has suffered for that reason.
So how would you have assessed a file when it came in? You would look at the nature of the file and the complexity and give an estimate to the client?
Well, if the client asked for it, you wouldn't give an estimate unless they asked for it.
Right.
But
You'd simply
I know that one of my compatriots, Stuart Tom, who was sort of one of my confreres at the same time, he was surprised when I said that no client had ever asked me to estimate the cost of the work before I did. He said people always ask to estimate before they did the work. It's a surprise to me. But no, I never was asked to estimate in advance, and I never did. I always did. If the work proved to be virtually useless, I wouldn't charge for it at all.
Right, yeah. And do you think perhaps that's a reflection, the docketing issue, that that's a reflection of a change in law from being a profession to a business, which is, some people
I'm afraid
believe
that's the answer. I know, especially girls who've gone through law, and they've stuck it out for a couple of them, they've dropped out, they've quit.
Right.
As opposed to get out of paying the huge errors and omissions insurance costs and the annual fees.
Yeah.
They just can't stomach it anymore, and they just quit. I think that's going to be the pattern if they don't do something to limit this, what I call sheer waste.
Yeah.
See, we had no errors and omissions insurance, except about the last year or two I was in practice, we used to get our errors and omissions insurance from Lloyd's of London for $250 a year. That was all we paid.
Oh, that's nice.
And that covered
all
we needed. But gradually it went up and up and up.
Yeah.
So that it's become prohibitive now.
Yeah. Yeah. Well, we were talking earlier about some of the courses that are taught in the bar admissions course now, including practice management and accounting, and professional conduct. And do you think that that's where those courses should be? Should they be there, or should they be in law school?
Well, there's been a lot of discussion about restructuring the legal education system, and I have not been a party to that because it's been in the legal education committee, which I've not been a member of. But they have discussed substantial changes in the legal education system. What direction they're going, I really can't tell you.
As far as your opinion, though, about what kind of training a lawyer should have,
well,
and when?
I think my own thought is he should have that kind of training which would enable him to conduct his practice. Now, professional conduct, he'd need to know something about it to conduct his practice, but it's not a big subject in the center. Legal ethics, for example.
Right.
But these are the things that sort of become disproportionately large if there's not something in control over them. They take too much of your time.
Now, I guess a part of the teaching of ethics and professional conduct is to protect the community and to give the lawyer or the law student knowledge about what their role
Yeah.
is. I wanted to ask you about the role of a lawyer. Do you see it as essentially a service to the community? Is that the nature of law, or do you see it in another way?
Well, no, I think most lawyers acknowledge that their justification, their existence, is as public servants,
Yes.
and that they must conduct their practice in such a way as to avoid causing public problems. And
Yes.
if they see a lawyer who has departed from the routine that's charged with professional misconduct, now the acknowledgement that, see, the Law Society Act, if you read the Act, I think it says the Attorney General is the protector of the public interest.
Right.
And I don't think that any lawyer would deny that this rule is really geared to the public interest.
Right. Right. It seems to me that some of the changes in legal education have been perhaps made with a view to protecting the public, as I said, and for the public interest. So you mentioned earlier, insurance and how expensive that was. But that's set up in order to protect the public.
Exactly.
So how do you balance those two things then?
Well, you can't really. I find it's the same as pediatricians have given up delivering babies because they can't afford to buy the heirs and omissions insurance. Well, the same thing is happening in law, but not to the same extent. But I think a lot of people have dropped out of law because of those heavy expenses of insurance.
Yes.
And there's no reason why the Law Society should not provide this insurance at a cheaper rate. I think that get out of the commercial side of it.
Right.
See what I don't know what they provide today, but they charge too much for it. I think that's my thought.
Right. Right. So a better balance of keeping lawyers, being lawyers, and protecting the public at the same time. Do you have any thoughts about legal education for the future in Ontario?
Well, legal education, as we said at the beginning of this discussion, means different things to different people. I say legal education is teaching a person how to be a lawyer.
Yes.
Not the legal principles of what the speed limit is or what income tax rates are, but to teach them how to meet a client, how to conduct a trial, how to argue an appeal.
Right.
Those are the aspects of teaching of law that I think should be important. I'm not sure that everybody else agrees with me, though, and that's
right.
They think that a large measure of academic instruction is necessary, and you can sort of, the rest will take care of itself. I don't think that's true.
What about...
I think every lawyer should, in his scholastic period, if possible, at least be articled to a senior person who can teach him how to do things.
Yes.
Or her. And who would take the student on trials and on appeals, so that they would see that firsthand how it's done.
Yes. What about the importance of some universities talk about the importance of thinking like a lawyer, so learning how to think in a particular way and how to find what you need to find, so how to research and find that material. Is that something you can learn?
Most lawyers, by the time they're starting to practice, they know how to look up and find what they need.
Right.
If they have a question that asks the question. They don't know the answer, but they know how to find it.
Right. So
But
that's
you
through...
don't find it unless you have the question.
Sure.
But I think that the how to conduct the law is the important aspect of legal education, and not the teaching of law in an academic sense.
Mm-hmm.
I don't know how law offices operate today, but the feedback I get from young lawyers is that they're very unhappy the way law offices are conducted, with dockets and so on.
Yeah.
Perhaps you know more about that than I do.
Now, you obviously enjoyed the practice of law, so those types of things weren't issues for you going through.
That's right.
Yes. Now, I guess the last question I'd like to ask you today is, again, a reflective type of question. A lot of what you've done over the years has been a service to the legal community. You taught for a number of years. You served as a bencher, and you served as a treasurer.
Yes.
You're a bencher again. Could you comment on that? You've had this life of devotion to the legal community, a lot of work and a lot of service. Where does that come from?
Can we justify the lunches that we get? I think that the legal profession has been served pretty well by the Law Society and by the benchers. And the only thing that, oddly enough, at the last convocation I was at a week or so ago, the present treasurer, Frank Morocco, but his predecessor was this Krishna. Mm-hmm. He was the best we've had in a long time, in my opinion. And I was discussing with him invoking a rule that would limit the amount of talking a person could do.
Right.
And we both agreed that the time had come for such a rule. The Supreme Court of Canada will limit the amount of time to argue a case.
Yeah.
The last time I was there, I was given 10 minutes. And it was ample time to present my... I mean, people can talk forever if you give them a head.
Yeah.
But the convocation is run loosely and wastes a lot of time.
Right.
Nevertheless, they do get the work done.
Yes. And I guess what I wanted to also ask you to continue along that line of questioning is, you've done all this work for lawyers for so many years. What motivated you to do that?
Well, really, it's very hard to answer that, because you ask what motivated me to go to law school in the beginning. That's very hard to answer, because I suppose simply because of the various options I had: dentistry, medicine, a few other professions that occurred to me in law seemed to be. My father always said a man had enough problem with his own without taking on other kinds of problems, so that he was against taking a law course. Notwithstanding that, I started it, and I was very lucky to get into a very good firm, and I found them very congenial. And to go on a trial with a good lawyer was an experience.
Yeah.
And I just carried on. There was no, once you get started, either you stuck with it or you didn't. And I found it most rewarding, so that I did.
Yes. And the service that you did, the committees you attended, you're acting as a bencher, you're teaching, did that all fit together as well? You just enjoyed doing that?
Well, it did, but not in a very meaningful way. As a teacher, I regarded that as rather a task. Right. And I didn't particularly enjoy it. But I knew that somebody had to do it, and it was better if it was done by somebody that understood how to do it. And during the years I taught, I think was worthwhile. And I learned,
Yes.
as I had to learn this stuff myself
Yes.
to teach it, so it was helpful to me in that way.
And you were saying earlier how much you enjoyed being a lawyer. You were with the same firm throughout your legal career.
Yes, isn't that?
Yes.
I was with the same firm from the day when I started as an arguing student.
Yes.
I stayed with that firm right through to the end.
How many years was that in all?
Well, I started in 1932,
Mm-hmm.
and I was retired in 1998.
Yeah, wonderful.
It's a long
Not
period.
many people could say that.
No, they couldn't.
Well, thank you very much.
So,
And